Call the next case on this morning's 9 a.m. docket, State of Kansas versus Laroy West. Case number 127290. Counsel, when you're ready, you may approach.
Michelle Davis, appearing on behalf of the appellant, Mr. West. May I please reserve 2 minutes for rebuttal?
You may.
Thank you. In this case, the state convicted Mr. West of premeditated murder. The incident happened at a quick shop. The security guard there, who's wearing all the full regalia, armed, everything, uniform as a security guard. The quick trip cop, I think is what people call him, confronted him inside the store, kind of marched him out of the store and through the lot, and the men are sparring back and forth. Mr. West crosses the street and the guard stays on the quick trip side of the street and is still talking to him and gesturing, and Mr. West says something to him and then turns to go and walk away down the alley. Whatever he says, the guard charges across the street and takes a fighting stance and punches Mr. West. And then over the next 90 seconds, does a continuous attack, pushing him, lunging towards him, and according to Mr. West, verbally threatening him. At some point, when he goes again to go at Mr. West pulls a gun and right out in front of him, the person standing right in front of him, and shoots once. And as a result, the security guard died. Mr. West asserted that his actions were justified as self-defense, and the court did instruct on self-defense. The state requested that the court also instruct that self-defense is not available to a person who initially provokes. The statute says the use of any force. The Pitt committee changed that to an attack. So the jury was instructed initially provokes an attack on himself, or physical attack, which is not correct because, as this court has pointed out, the use of force can be verbal. It can be a verbal threat. It can be a display of a weapon or the display of force. It doesn't have to be a physical attack, but that's what the instruction says. It provoked a physical attack, intending to use this attack, such force, is what the statute says, as an excuse, justification to inflict bodily harm upon the person provoked. And then the state then argued that Mr. West was not entitled to claim self-defense, and the lesser included defenses of imperfect self-defense, voluntary manslaughter, and involuntary manslaughter did not apply because he was not acting lawfully, because he had provoked this attack upon himself. The defense counsel objected to the giving of this instruction, saying it was factually inappropriate and legally incomplete, and defense counsel requested the court instruct on what it means to provoke, and that words or gestures, however insulting, are not sufficient to provoke. So basically, all the jury had to find is that the person was provoked, which is they responded. He was provoked. Bam. The intent.
Let me just ask a question,
okay,
which it's kind of confusing to me, but in your brief to support, the fact that it's like the jury instruction was not factually supported with evidence that your client intended to provoke, you cite a Washington state case from 1999 saying that words alone are insufficient for provocation. But isn't that argument undermined by a lot of cases in our jurisdiction, finding that a defendant need not necessarily initiate physical contact to provoke within the meaning of 21-5226?
I think we have to slow this down a little bit.
You what?
I'm trying to understand what you're saying. The defense counsel argued that the instruction was factually inappropriate because there was no evidence that Mr. West intended to provoke the attack, was defense counsel's argument. And then your second part about the Washington case, going through my brief, I believe I cited that for this idea that you have to be, the provocation has to be sufficient to justify the use of force under the law. That's where I cited the Washington case for. So unless you can refer me to
Okay,
my brief, I'm not sure where we're.
okay.
So that the Washington case was Kansas really, the judge didn't give the instruction, the language requested, it gave the instruction. Didn't give the language requested because the judge said there's nothing in PIC or case law to support this. And that's true. Kansas hasn't dealt with this issue. But as I point out in my brief, I cite the cases that I cite where the initial aggressor or provocation had been given. In all those cases, the person's approaching with a gun. I mean, they're in a situation, they're putting themselves in a situation with a gun. And a gun is the use of force because you're displaying the means of force. So I have not seen a Kansas case where just words alone are sufficient.
Like, here, State v. Collins from 2020, defendant initially provoked victims' use of force against him when he verbally rekindled a conflict.
That was a probable cause case, though. I mean, that's an immunity case. So that was a probable cause case, and it wasn't.
What about
under that threshold? I mean, words can provoke if they're threats, and that case didn't really clarify what the words were.
What about in Salary from 2015? The defendant was the initial aggressor who was ineligible for self-defense, where he refused victim's order to leave her house.
And he stayed with a gun at his side. He stayed in the house with a gun at his side.
Defendant left the room before returning with a loaded fire.
Yes, that is use of force. A display of the means of force is the use of force. So.
But we're talking about provocation.
Right, and so that's our point, is that the provocation has to be sufficient to justify the use of force. If you display a gun at somebody, then you can provoke the use of force because you are.
Displayed a gun at somebody here.
That's my point. That's my point, is that you can't, okay, any provocation is not sufficient. It has to be provocation that justifies. The security guard, when he attacked Mr. West, he is not justified under the law to do that because you can't physically attack someone simply because they call you a coward.
Undisputed in the record that once he crossed the street, that the security guard just decked him.
Yes, he ran after Mr. West crossed the street. There's more talking. He turns to go. The security guard runs across the street and does the whole physical attack. Mr. West does not respond. He does not physically attack the man. So that's unlawful. Security guard is not justified under the law in doing that.
Okay, and who testified to that? West? Because I looked at the video and, maybe I just can't enlarge it big enough because it was pretty far away.
But you can tell from the video who's doing all the force here. You can tell from the video that
it looks like the security guard is going, hey, calm down, man.
At some point in the video, you could maybe infer that, right? But there's also lots of times when he's doing what I talk about in my brief, where he's pushing him, he's in his face, he's lunging toward him. And Mr. West is not doing any of those things. You can look at the video and you can see that he's back on his heels. It's the other person who's doing all of the aggression.
Wasn't there a witness who testified? I'm sorry, there's just a lot of facts in this case, and I just, the video was hard to see. Was there a witness who said that your client said, you want a piece of me, come over here? Or what was that?
So what you have is, there's some people, you've got standard quick shop and I'm facing towards the front. There's some gas pumps out on the side. There's a guy standing at the gas pumps. The two men are quarreling as they're leaving. And the guy at the gas pumps sort of just said they're just talking back and forth. And I remember hearing at some point, you won't come over here, nothing but a coward.
Right.
And he didn't remember who said that. According to the state, the detective wrote that down. He thought Mr. West had said that. But that's the testimony. So you're talking about somebody standing at a gas pump, and you can look at the diagram. The map is in the record.
He heard, according to him, West said, come over here, you're a cow.
He didn't say that. The detective said he said that after the incident happened. He heard the men, he initially was inside the Quick Trip. He hears the men arguing because there is an initial.
And they walk out. And
he walks out at the front door. And then he tells the police afterwards, I heard these words. I don't really know what they're saying. I just know there's an argument going on verbally. But I remember you ain't going to come over here and you're just a coward.
Right, but I mean, that obviously happened after the guy was across the street.
You could infer that. It just wasn't
Well,
clear.
right, because come over
Right.
here.
He didn't, right, but I mean, the testimony wasn't clear about that. So,
Why is that not clear?
because he said that as the men were walking through the lot, he overheard. That was his testimony. But my point is, even if you want to say, I'm not going to argue the fact with you, it makes sense what you're saying.
Okay.
So if it was at that point, that's still not enough to justify
Why
the
not?
man attacking him. Under Kansas law, you cannot physically attack somebody because they insult you.
Well, because, I mean, you're, okay, all right.
So I think what we're trying to point out here is that there's a difference between there's a difference between verbally provoking somebody and verbally provoking the use of force. Those are two different things.
Okay, and so if this instruction had not been given, that, do you think the jury would have come up with a different verdict? I know it's not your burden because you asked for that.
Yes, because based on Mr. West was justified in using force to defend
Deadly
against,
force.
that's different, okay? For example, imperfect self-defense, involuntary manslaughter says he had the right to use force. Okay, at the time the security guard is coming at him and he's been attacking him for 70 seconds. Mr. West has the right to use force to defend himself. Now it's arguable, does he have the right to use deadly force?
Right, but he was convicted of premeditated murder, not.
He could have been convicted of involuntary manslaughter. I mean, this case is perfect for involuntary manslaughter.
What facts would show that?
Because
did West testify? Oh, I mean, what facts would support the lower instructions?
Because he was entitled to use force to defend himself. Force being not deadly force, just force. And he testified that he believed he was in fear of imminent death or great bodily harm. So he reasonably believed that his use of deadly force was justified.
But
then you get to the lesser. That's what the lesser covers.
okay. I'm sorry I took up so much of your time.
That's okay. So and the thing I want to distinguish is between threat can be a force, but it just depends if it's a defensive or an offensive threat. So for example, if I say, don't come over here, I'll defend myself. That's a threat, but it's not an offensive threat. That's a defensive threat. So threat by itself isn't necessarily the use of force. And that's why this instruction needs to be really carefully tailored so that it conveys to the jury and harmonizes with all the other statutes as to what you need to be provoking. And it's our contention that it simply didn't do that in this case. And I'm low on time, so unless there are other questions.
Any other questions, colleagues? Thank you, Ms. Davis. Mr. Mahoney.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. It appears that the majority of counsel's argument today was focused on issue 2, so I'll mainly focus there as well. I think in doing that, one of the things that I'd like to urge the court to do is to obviously look at this entire encounter, this entire situation in its totality. In much of the brief, it felt like the defense was essentially trying to look at this as if the altercation or the argument started after both men were in the alley. And that's clearly not what happened in this case. They first came into contact inside or just outside the Quick Trip. And the testimony was that essentially the defendant was playing this loud music on a speaker. The security guard was doing his job and essentially asked him to either turn it down or turn it off. The defendant, and I think the video clearly shows this, he was not particularly cooperative. He continued to argue, eventually was essentially told to leave. And he continued to argue and yell at the guard as he was being escorted off the property. And then you see that the guard does escort him to the edge of the Quick Trip property, still on the Quick Trip side of the street. The defendant continues walking across the street toward the alley, and the security guard does start to turn and walk around to go back to the store. So he was disengaging. And one of the employees from Quick Trip who was in the store when the initial verbal dispute happened said that the security guard was doing his job. He was essentially trying to de-escalate this and just tell him to stop playing this loud music because obviously other customers are in the store. So in any event, they get to the edge of the property. The defendant continues and goes across the street. The victim starts walking back to the Quick Trip, obviously having disengaged. It's going to go about the rest of his evening. And then the video supports the testimony from the witness who said that he then heard the defendant say, "You're a coward. You ain't going to do nothing about this." So that is then what leads to the security guard going across the street into the alley. Now, once they're in the alley, I agree with Your Honor. The video obviously is not of the greatest quality because the alley is far enough away from the Quick Trip that even when you do use the zoomed in version of it, it's not like it's a particularly high quality video. The defendant obviously claimed that the security guard was beating him severely. He claimed that he was punching him. He claimed that he hit him so hard that he almost fell down, that he almost lost consciousness, that he was fuzzy. I would point out that I don't know that the video would necessarily support that version of events. I think that there is some initial contact where you could think that what the guard did was maybe a punch. It could also be more viewed as a shove. The later contact, I would argue, is almost exclusively, I think it is fairly clear that there's some contact, but it is more along the lines of just some pushing and shoving. There are also stretches where there's no physical contact. And at the moment that the shot was fired, there absolutely was no physical contact. The defendant was not being touched by the victim at that point. They were standing a couple feet apart, I mean, admittedly close, but there was no physical contact. He wasn't being beaten by any means at that point in time. And as everybody acknowledged, there's no indication. The victim never drew. He had a service weapon, that he had a gun in the holster. He never drew it. The defendant never even so much as said that the victim reached for the gun or said that that made any indication that he was going for his gun.
Let me just interrupt real quick. I just want to make sure the jury saw the video.
Yes, yeah, the video was admitted.
Right. And then was there testimony from the police officers or whoever responded to the scene that did he have injury? Did the defendant have injuries consistent with being beat as with his testimony?
Right. So he wasn't arrested until a little bit later, but there was testimony that he had no visible signs of injury when he was taken into custody. I can't remember if that was the next day. It was within a relatively short period of time, short enough that if he had in fact been badly beaten on the head to the point where he was, in his words, almost about to pass out or lose consciousness, I think reason would say that he would have some sort of visible head injuries or face injuries or something, but he had none of that when he was arrested relatively soon after this crime. But our position is that as it was briefed, essentially, so what happened at trial is that the state requested the instruction on provocation. The court granted it. The defense objected to it and then said, if you are going to give it, we want you to add language that words are not enough. And the court, I think correctly, basically said, look, that language is not in the pattern instruction. There's no case law support for it, and therefore declined to give it. The language that the defense is using, and really the way they brief this, is just trying to use it from the context of a separate instruction that talks about the, I guess it's the voluntary manslaughter. But those are two very different things. And so I don't think that
Should
it
it
was.
be, go ahead, I'll jump in and just try to zero in on this provocation question.
Mhm.
As I understand defense counsel's argument, and defense counsel might correct me on rebuttal if I say this wrong, it is that the only provocation which could negate a self-defense is provocation that would justify the lawful use of force. And I guess my question to you is, it seems like you're taking the position that the statute doesn't say lawful use of force, it says any force. Is that a correct summary of your position on provocation?
Correct. And I think also the statute, there's nothing that restricts in this context the instructions to situation where it's only appropriate to give this provocation instruction if there's some sort of
Right,
physical.
so in other words, words can be enough
Yes,
under the
yes.
statute, because the statute just says provokes the use of any force.
Right.
Whereas the argument of the defendant, as I understand it, is that words can't be enough because words could never justify the lawful use of force.
Right.
And it's that lawful use versus any force, that's the distinction.
Yeah, that's a distinction. And I think the case law, I know Justice Standridge pointed to a couple of cases. I cited in my brief, Beard and Hunt are the cases that talk about generally whether the provocation instruction was appropriate. And it just basically says, look, it's a correct statement of the law. It's not telling the jury that the victim was the initial aggressor, or that they provoked it. It's just instructing the jury so that they're aware of what the law is. In Beard, the Beard court certainly didn't engage. That's an older case, and like a lot of cases from that time period, the analysis was not particularly lengthy. But from reading that case, it certainly appears that the only thing that did justify the instruction in that case was words that the defendant had used. Specifically, and I cite this on page 20 of my brief, that it appears that the only evidence supporting the provocation instruction there was the fact that when Beard returned to the scene where he had previously been in an altercation about an hour earlier, and then when he came back, he said, "I told them I would be back." And then after he made those statements is when the physical altercation that ultimately ended up in the crime occurred. And so I think that, yes, I think that case does support the proposition that mere words can be enough in certain contexts. And it is, again, this is the critical part. It's simply a question for the jury. This is not a situation where the court informed the jury as a matter of law. The defendant said, "You're a coward, you're not going to do anything about this, therefore he is deemed to have been, provoking this incident." He simply instructed them, gave them an instruction that is consistent with PIC and with the law, and we think that that was, in fact, an appropriate instruction here. And I think that there is a reason to distinguish this from the context of voluntary manslaughter, where you're talking about, which is the context where generally the mere words or gestures are not enough, case law comes in. In that context, you're looking at purely that's an objective only test for in the voluntary manslaughter context. This is self-defense context, and you're looking at it both from the subjective and objective standpoint. And I think in a situation where somebody like the defendant uses words to essentially taunt or bait somebody that he's in a verbal dispute with, and lures him essentially to come into that alley, I think that very much cuts against the subjective prong, that he's not acting because he's in fear. He was essentially, as I argued in the brief, if you buy the defendant's argument that mere words can never be enough to be provocation in this context, you're allowing the speaker to weaponize their words and to use them as both a shield and a sword. You say something to somebody, when you make a comment like that, you're very clearly intending or at least aware of the possibility that your words are going to lead to this physical confrontation. And if you make a statement like that and you get that desired result, which is, okay, I provoked the, you know, I taunted this guy, I called him a coward, I basically said that he was afraid to do anything about this. Well, now my words have the desired effect. He comes over and we're in this physical dispute now. The speaker shouldn't be allowed to then provoke that incident and then turn around and say, okay, but then ultimately I acted in self-defense when my words are what started this. I think when you look at that video in conjunction with the testimony, because there was the witness testimony that somebody heard him call him a coward and say that he wasn't going to do anything about it. And then when you pair that up with the video, I think it shows very clearly that this guard he had walked him off the property. He had done his job. He's a Quick Trip security guard at the boundary of the Quick Trip property. And once the defendant's off the property, the security guard has done his job. He turns, he's ready to go back inside. He actually takes a couple of steps back inside. And then at the time that the defendant makes these remarks, that's when he starts following him across the alley. Now, we can obviously debate whether that was a smart decision by the guard or whether he should have simply gone back inside, but that's not what we're here to discuss, is whether he acted, you know, in the smartest way possible that night. The question is, can those words at the end of that type of a dispute be enough to provoke somebody in this context? And I think it is. It's certainly enough for the judge to at least instruct the jury on it and let them make that decision. And that's all that happened in this case. This was not a matter of law. It wasn't like it was an instructed directed verdict or something on that particular element. It was just informing them accurate statement of the law.
Can I back you up too? I had a very similar question that Justice Steagall did about the statutory language in the initial aggressor statute and the distinction between any force and any lawful force. And you would agree that there's also an intent element to that subsection B of the statute, that it's you know, the provocation for any force, but there has to be some evidence of an intent to sort of induce the other party to engage in order to inflict bodily injury upon that individual.
Right. Yes.
And I'm not suggesting there isn't evidence
Right,
of
no.
that in this record, but that would be, there's really two components under the statute.
Yes, there are. Yeah, there does. And that's something I think that the circumstances would show that intent, again, that there was at least enough evidence to make that a fact question for the jury, which is what the Hunt and Beard courts have said, is that this is something that when there's some evidence to support it, it's appropriate to give this instruction to the jury just so that they're aware of what the law is. And I think clearly in this case, when you look at that argument and you see what he did, and obviously the other incident that was so similar, where he's on private property of a business, he's confronted by an employee basically telling him to get off the property, and in both instances he not only doesn't comply, but he starts arguing. He ultimately, in both occasions, he has a weapon with him that he displays and unfortunately, tragically used on the night of the Quick Trip incidents. So I think there was ample evidence to show that it very much was his intent. He was trying to stir things up. He was trying to provoke something. He was angry that he had been essentially kicked off the Quick Trip property. And so those words did have an intent behind them. I see that I'm at my time, and I'm sure everybody has had more than enough of me already today. So unless there are further questions, we would just respectfully ask this court to affirm the defendant's convictions.
Any further questions, colleagues? Mr. Maloney, thank you for your argument.
Thank you.
Ms. Davis, you reserve 2 minutes.
So the initially provokes the use of force. One part of the statute requires the intent element, which doesn't have to be proven. It can be inferred. But there's another subsection that also says provokes the use of force and doesn't require intent. It requires other circumstances. So this court's ruling is going to have broader application. when I say the use of any force, I see that as including deadly force. Any force is just force and deadly force. So basically the statute says if you provoke the use of any deadly force. And
But does it have to be lawful? I
Well,
mean,
that-
because I understand,
Yeah,
you
but
can
even-
correct me if
no, but even following your argument, let me finish. Even following your argument, you have said in the context of voluntary manslaughter, you cannot provoke the use of deadly force with words.
Right, but if we're looking at, I mean, the state is arguing that that's a
You can't-
different area of the law that
That's
we,
why you have to read the statute as lawful force, because if you read the statute, provoke the use of deadly force, and that can be anything. That provocation can be anything.
But that's
It's
what-
totally,
that's what the
totally
statute
does
says.
not, I'm sorry?
Isn't that just what the
But
statute
you know
says?
what? You've got voluntary manslaughter, heat of passion, and you say it has to be reasonably adequate provocation. That's not in the statute. All statute says that you kill somebody in the heat of passion. Reasonably sufficient provocation, words aren't sufficient. None of that's in the statute. That's this court's interpretation of the statute.
It's the interpretation of the crime, whereas this is an exception to a defense. And doesn't that
Right,
make a
but
difference?
provocation has to be universally applied. You can't
Why?
say,
Why does it?
because you've said in the context, you cannot provoke deadly force by words. This statute says provokes the use of deadly force. That's what the statute says. If you're going to say it can be anything, you are saying words can provoke the use of deadly force. That's what you're saying.
Well, that's not what I'm saying. It seems to be what the statute says.
If you interpret that statute that way, otherwise, please interpret voluntary manslaughter to simply be a killing in the heat of passion and nothing else, because nothing else is in the statute. The second thing I just wanted to say is that have you noticed on two of my issues that it's the attorneys that are defining the law for the jury? That's the problem. There's no standard here. So when they're arguing whether there was provocation or not, they're telling the jury what the law is. Defense counsel is saying it's not the law in Kansas that you can call somebody a coward and that justifies an attack. And then the state's telling the jury something else. What does that tell you? There's something, it's the judge who's supposed to be instructing the jury on the law and defining the law. And the same with the involuntary manslaughter self-defense. Because the judge doesn't tell the jury adequately what the crime is, the attorneys are trying to do it in closing argument. And that's totally inappropriate. And I am out of time.
You are. Any questions, counsel? Ms. Davis, thank you for
Thank you.
your arguments here this morning. That concludes the 9 a.m. docket.